On November 26, 2021, the LSE Council admitted to the UK Information Commissioner's Office that it denied holding Tsai Ing-wen's Viva reports. That runs contrary to the presidential office's claims that Tsai's Viva records are kept at LSE. Tsai's lawyer Lien Yuanlong then tried to convince people that information pertaining to Tsai's PhD would be kept at the University of London, but that was proven incorrect by a response on whatdotheyknow.com. If anything, the University of London would keep a minimal amount of information. University of London would only keep records on the name of a graduate, date of degree conferment, constituent college, and thesis topic. The University of London Transcript Office would keep a copy of Tsai's diploma, but LSE would have all other information and records. There is no doubt that LSE should possess the majority of a PhD recipient's records. So, when the LSE Council says that it doesn't have Tsai's Viva report, it's trying to cauterize the damage already done. The LSE Council basically denies Kevin Haynes and Rachel Maguire's claims that the school possesses extensive records on Tsai's time at LSE. That means the LSE Council also shuts down the possibility that Tsai's Viva took place on Sunday, October 16, 1984, and that her examiners were Michael J. Elliott and Leonard H. Lee. The Viva date and examiners' names were two crucial pieces of information that factored into Huang Wei's decision to indict Dr. Dennis Pang. Now, that information has been debunked and stands as proof that LSE has faked evidence. It's clear that Haynes and Maguire are working with national security organizations in Taiwan to cover up the truth. "2022 finds ThesisGate in a whole new set of circumstances. First, University of London Data Protection and Information Compliance Manager Kit Good has left his post. Susie Merriweather has taken his place. Mr. Good had several exchanges with Dr. Huan Si-lin and Michael Richardson. In the early days of ThesisGate's investigation, Dr. Lin received an email response from Kit Good in June 2019 that read, "In regards to whether the Institute of Advanced Legal Studies received a copy, the university does not have any formal acquisitions records for theses from the 1980s, though correspondence records indicate a copy was sent from Senate House Library to IALS at some point in the past. However, this copy currently cannot be located in the IALS library." Even though ThesisGate still hasn't received the attention it deserves, this early email from Good is full of red flags that should have been noticed. Good seemed to spin the narrative that Tsai's thesis was lost, insinuating that it actually existed. He used vague wording to indicate that a thesis was sent to school libraries at some point in the past. Good's position then was consistent with LSE's October 8, 2019 statement on its website. It seemed that both these parties used vague descriptions to allude to the 2011 thesis smuggling incident. But just like how LSE's statement contained the exact same syntax and diction as Shi Fanglong, Good's words betray that he is somehow connected to this cover-up. In November 2019, ThesisGate discussions in Taiwan were heating up. Kit Good was the first person to openly say that LSE granted Tsai Ing-wen a degree in an email response to Michael Richardson. The timing of Good's response was crucial as it happened right before Taiwan's presidential election. This is what the email said. The University of London confirms that Miss Ing-wen Tsai was awarded a PhD by the University of London in 1984, and she was registered as an LSE student. Good's email referred Richardson to the October 8, 2019 statement. This is in line with how the wrongdoers operate. They use evidence that they craft themselves to prove their own points. Later on, Kit Good's answer would be used to respond to inquiries on whatdotheyknow.com, practically copy and pasted on there. On June 11, 2021, the ICO's first ruling came out. This was the same ruling Lin Yuanlong cited in his 4-part statement. Point 35 of the ruling states that the university has told the commissioner that it had Tsai's thesis record. Point 37 says that the university has advised that the school has Tsai's Viva report and that it has records of conferring a degree to Tsai. It's evident that the same person in charge of the ruling is getting their directives from the same person as Kit Good. The person who advised the ICO ruling on behalf of the University of London is the only other person to publicly say that Tsai got a degree from the University of London. They also make the important claim that the school has Tsai's Viva report. This ICO ruling is the reason why Michael Richardson lost his case with the Tribunal Court on September 13, 2021. The UK's tribunals have no investigatory privileges, so it had no choice but to take the University of London at its word when issuing its decision. Kit Good left the University of London earlier this month. Another key player in crafting the ICO's first ruling is Information Commissioner Elizabeth Denham, who left her post in November. John Edwards officially replaced Denham in this position on January 4, 2022. Susie Merriweather took over as the University of London's new Data Protection and Information Compliance Manager in September 2021. When faced with questions from the public, Merriweather no longer responds using prepackaged statements like Kit Good did. Last time, we talked about how Merriweather explicitly said that the University of London would only keep a minimal amount of information on LSE graduates. Everything else would be at the constituent school. This includes Viva reports, examiners' names, and so on. Most importantly, Merriweather revealed that Tsai's Viva report is not at the University of London or LSE. In response to an inquiry by investigator Tsai, Merriweather wrote the following. The University of London has not published this thesis, as no physical copy of the thesis was received by the university from the examiners. Merriweather then suggested that Tsai request what they were looking for from the London School of Economics. Li Xingchen, another devout ThesisGate investigator, cited the LSE Council's claims that it did not have information on Tsai's PhD and asked if the University of London had provided any information to LSE about Tsai's PhD and Viva. For example, they asked if the University of London gave LSE information about Tsai Ing-wen's Viva date, which Rachel Maguire had previously provided. Merriweather responded thus. I am sorry, but the University of London does not hold any information relating to information held by LSE about Ing-wen Tsai. I am unable to give you any information in response to your questions about this. The primary record for PhD awards is held by the member institution, not the University of London. Merriweather's response debunks information from the ICO's June 11, 2021 ruling. The ruling's 35th point clearly said that the University of London told the ICO it had records on Tsai Ing-wen's thesis. The 37th point said that the University of London advised that it had files supporting a passing result for Tsai's Viva and that Tsai was given a proper degree. If the University of London now admits that it did not publish Tsai's thesis, nor that it has her Viva report, then the ICO ruling now carries absolutely no weight. This not only suggests manipulation of facts, but it also brings into question why Michael Richardson lost his ICO appeal in the first place. The two people of interest here are Kit Good and Elizabeth Denham, as they have shown their inclination toward proliferating false claims to vouch for Tsai Ing-wen. ThesisGate is not only about testing Taiwan's political morals, it's also about the country's social values. Ever unhappy with these new developments, righteous investigators have demanded that the ICO change its ruling. Another ThesisGate investigator, Wen Ting, challenged the ICO on its June 11th ruling on WhatDoTheyKnow.com in 3 points. One, please disclose any meeting minutes, including web conference recordings, email correspondence, text reports related to the wrong conclusion reached by the ICO ex-commissioner in the decision notice. 2. Has the ex-commissioner or case investigator ever asked the University of London Library to provide a record of entry for this disputed thesis? If not, why? It was clearly stated in the email statement by the librarian that it was never received by the library before the investigation. 3. How does the ex-commissioner agree the original copy held by the university library was lost or misshelved sometime between the mid-1980s and 2010s, a period that saw numerous structural changes to the library? Who provided the false information and time frame 1980s to 2010s in regards to the misshelved information? Not long after John Edwards took up his post as Information Commissioner in 2022, he was tossed a hot potato. It's clear that his administration isn't as keen as Denham's to keep a lid on things. Taiwan's presidential office has chosen to stay completely silent on ThesisGate. Crucial details of the scandal continue to come to light. Tsai Ing-wen's grasp on the situation is starting to wane. On January 17th, Dr. Lin struck again. He sent an email with 3 questions to the University of London and LSE. He asked about the possibility of P.C. Kennedy's letter being forged, Tsai Ing-wen's timeframe on her thesis submission, and requested that LSE withdraw its website statement. Dr. Lin's purpose was to bring this scandal to an end. ThesisGate developments may seem to be dwindling now that things look like they're reaching their end. However, the fact remains that Taiwan's judicial morality leaves something to be desired. Taiwan's courts continue to work on Tsai's behalf, so it's imperative that investigators continue to stay vigilant in ThesisGate court cases, if for no other purpose than to document the unfair treatment they receive. The case against Zhang Yonghui stemmed from a court case brought forth by Dr. Dennis Pang. It was a lawsuit that aimed to prove that Tsai's thesis didn't exist. Judge Zhang Yonghui initially dismissed the case, only to have the high courts send it back to the district level. In the case's second time around in the district court, Dr. Pang ended up pressing charges against Judge Zhang. The purpose of the lawsuit was to see if Zhang had deliberately botched the terms of the case, actions that arguably could have resulted in financial loss and mental distress for Dr. Pang. The presiding judge in this case was Taipei District Court Judge Hong Wen-hui. Hong seemed to abide by proper protocol throughout the proceedings, even allowing Dr. Pang to attend court procedures via teleconference. Dr. Pang made his case, saying that Judge Zhang released information about Pang's case dismissal to the media even before her official ruling had come out. Judge Hong asked the Taipei District Courts for its rules on press releases about rulings to determine if there was a leak. Judge Hong went so far as to look into the press release in question and adhered to proper investigatory protocols the entire time. Even in the face of despair, the ThesisGate movement holds out hope that there are pockets of righteousness operating within the justice system. That keeps the hope for revolution alive. Unfortunately, Dr. Pang lost his case against Zhang on December 30th, 2021. The reason was because Taiwan's laws categorize judges as specialized public servants that shelter them from being held accountable for damages. Such preferential treatment for government officials is one of the reasons why Taiwan's justice system will never win the people's trust. Even more important, however, is how the truth gets distorted in the courts when ThesisGate comes into play. Dr. Pang's case against Zhang manages to baffle the public, even though that's what our followers are already used to. First, in her case, Judge Zhang made the case about proving whether or not Tsai had a degree. This was an early strategy in Tsai's counter-campaign against ThesisGate, which rested on the claim that the existence of a degree proved the existence of a thesis. Dr. Pang, however, wanted the case to be about the existence of Tsai's thesis. This minor change was a subtle but cunning method to steer the argument into territory more favorable for Tsai. Even though Zhang changed the terms of the case, Hong ruled that this was inconsequential and didn't find Zhang to have deliberately altered the case in a manner detrimental to Peng. Hong said that the contents of Chang's ruling did not harm or distress Peng in any way, and that objectively there was no ill intent. So what exactly makes a ruling distasteful and detrimental? Did the ruling outright have to chastise Peng or contain explicit language? Hong's reasoning is clearly superficial. The importance of confirming the existence of Tsai Ing-wen's thesis was a matter of public interest and trust. Yet the media claimed Peng's lawsuit proved he did not have a sufficient understanding of the law, nor did his lawyers. The purpose of Peng's case against Zhang was to find out if Zhang deliberately changed the terms of the case in a way that was detrimental to Dr. Peng. Judge Hong said that Zhang's changes to the case were not detrimental to Peng's cause. That ruling was a mere justification to hand Dr. Peng another loss. There's a joke that goes like this. A lion sues a zebra because the lion says the zebra kicked him just as he was about to eat the zebra. The courts ruled in favor of the lion. This is the perfect metaphor for Taiwan's justice system. Hong added that because Zhang's initial dismissal of the case had been overturned in the high courts, the possibility that Peng suffered any distress or damage had been undone. The fact that Dr. Peng had to appeal to the High Court is already a clear indication that he needed reprieve from unfair treatment. How could that absolve the district court from its mistake? That's like saying a surgeon who performs the wrong surgery on a patient is excused from their mistake because they eventually fix the patient up. Judge Hong's decision shows flagrant favoritism for Zhang. Judges are covering for judges. That's what's happening here. There is also pressure from above. For example, the fact that Judge Zhang's ruling had been leaked at all hints that the district court intervened in Peng's case. At first, Hong was very meticulous when looking into the district court's protocols. On October 8, 2021, she very clearly laid out 5 specific points of interest. 1. Did Judge Zhang have a hand in writing the ruling's press release pertinent to the lawsuit at hand? Did Judge Zhang help write the portion of the press release detailing the ruling's main points? If the answers to these questions are no, then who is the one that produced the ruling's press release? 2. Did the court provide the press release to media outlets before its official publication? Or did the court provide the release to members of the media who came asking? Which media outlets were given the release? How were media outlets privy to the release's contents at a time when the ruling hadn't been published? If the courts gave the ruling to the media, why was it released earlier? Three. What was the timeline of the ruling's release? When was it put on the court's website? 4. Was the press release provided to media outlets in a physical or digital format? Did media outlets receive an original digital file from the court? 5. If the original digital file of the release still exists, please submit it to the case file. These 5 questions were posed in response to the ruling's early leak to the media. It raised the possibility that judicial officials had been pulled into nefarious political dealings. Just for posing the question, Judge Hong had guts. She was willing to stand up to the Taipei District Court. The district court responded to Hong's questions on October 25, 2021. The main point of its answer was that the court adhered to rules and regulations dictating ruling publications. However, the response also contained one very telling piece of information. After Judge Tsang's ruling came out on January 15, 2020, the District Court Public Affairs Office issued a press release on the primary points of the ruling and uploaded it to the court website at 3:54 p.m. that day. This was done so that members of the public could quickly understand the terms of the case. The press release was available to the general public, including members of the media. The court does not know how the media came to learn of the ruling's contents, whether earlier or not. The Taipei District Court answered the easy questions but disregarded the hard ones. It emphasized that the press release outlined the important points of Tsang's ruling and was uploaded to the website at 3:54 p.m. The court couldn't offer an explanation for how reporters preemptively knew about the ruling. What's strange is that Judge Tsang's lawyer very clearly said that Judge Tsang wrote the ruling herself, but had nothing to do with the press release. This means both the ruling and the press release were crafted separately. This means that the Public Affairs Office took a ruling made that morning, which consisted of a few words, and turned it into a full-blown press release by the afternoon. This press release didn't even mention the fact that Judge Tsang changed the focus of the case, which is a pretty big thing to omit. Does all of this manipulation indicate that there is someone else above the Public Affairs Office and Judge Tsang calling the shots and writing press releases and rulings? Judge Hong's questions to the district court shows that she recognizes there are irregularities here, yet her ruling says this. With regards to the press release, it is the opinion of the court that this case is of great interest to the media. The court uploaded the press release to its website at 3:54 p.m. that day in accordance with court rules. Media outlets may have requested that court officials notify them of any changes to the case, including the uploading of the ruling. That's how media outlets were so quick to act on the news. Strange. Didn't the Taipei District Court say it didn't know how the media got their hands on the ruling so quickly? Yet, Judge Hong came up with the explanation that the courts notified reporters when the ruling came out. Something is not right here. As to how the media knew about the ruling's contents beforehand, Hong said nothing. All Hong said was that Tsang had no hand in creating the press release. Judge Hong initially divided the chain of events into three different instances: the writing of the ruling, the publication of the press release, and the discovery of the release by the media. Not one person took responsibility for any of these actions. Judge Tsang wrote a ruling but didn't help craft the release, so the release is none of her business. Someone else at the court wrote the press release, which removed Judge Tsang from that process. How did the media find out about the release? No one knows. This is just how things are in Judge Hong's mind. Judge Hong's ruling points to another possibility. Neither the ruling, the press release, nor the media's awareness of the trial outcome is relevant, and that's because someone else wrote and disseminated the ruling and press release to the media, most likely the presidential office. Dr. Pang plans on appealing this decision. If Judge Tsang really is innocent, then we'll have the administrative courts explain how that is. How could media outlets get so much information from a small press release? Liberty Times News and Sanli's reporters knew details about Tsang's ruling before the courts even published the information. How did that happen? If the judicial system does not want to fight for justice, then ThesisGate will not spare it from the people's wrath. In 2022, we see that ThesisGate is beginning to turn the tide. The ultimate goal is to get the University of London to admit that Tsai is an academic fraud. LSE has abandoned the ship. The University of London is slowly coming around to the truth. Tsai's cover-up is about to end. Unfortunately, even as the waters recede on this scandal, Taiwan's justice mechanisms continue to drown. Not a single judge is willing to rule on the side of righteousness. They care nothing about Taiwan's national dignity. The day ThesisGate ends is the day Taiwan's revolution begins.